talking about the Bethel versus Fraser Supreme Court case. It took place in 1986 and was between the Bethel School District and a student. Yeah, Sarah?
Isn't that the court case where the guy made an inappropriate speech in 1983 and he got suspended?
Yes, and then his parents sued the school and they ended up taking it to the Supreme Court. I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm, but most of all, his belief in you, the students of Bethel, is firm.
You're being suspended for violation of the disruptive conduct policy, and you're not allowed to speak at your graduation, even though you're second in your class. Some teachers complained that your speech was really disruptive. They even talked about it in class and sent me letters.
This is so dumb. I was just making a campaign speech for my friend Jeff Coleman. I'm gonna get my parents to sue you. My First Amendment and 14th Amendment rights have been violated.
You haven't violated any of your rights, and you need to learn that your actions have consequences. Mr. Coleman will not be inducted into a student government office, even though he won the election by write-in. We, as a school, have the power to suspend you.
That's so unfair. Remember, the Supreme Court ruled in Tinker versus Des Moines that students still have constitutional rights even when they're in school. The Supreme Court said that students were allowed to wear armbands to protest the Vietnam War.
I can't believe it. The district court and the Ninth Appellate Court actually ruled in his favor. They even want us to reinstate him as a potential speaker at graduation. We need to appeal this right now.
Well, we've heard the facts. I don't think the First Amendment prevents school officials from determining whether or not to allow a vulgar speech that would conflict with its educational mission. Sexually explicit monologues should not be given in high school where they are directed towards an unsuspecting audience of teenage students. I believe it was perfectly appropriate for the school to make the point to the pupils that vulgar speech and lewd conduct is wholly inconsistent with the fundamental values of education.
I concur. Bethel High School has to regulate the speech of students, and the school did not violate the First Amendment or 14th Amendment in punishing Fraser.
Well, I dissent. There was not enough evidence to prove that the respondent's speech disrupted the education at Bethel High School.
I agree with Justice Brennan and concur with his decision that the school did not violate the First Amendment or 14th Amendment.
I agree with Marshall. I also dissent. The speech was not disruptive and therefore did not fall under the school's disruptive conduct policy. The warnings of the teachers to Fraser about making the speech did not notify him that he might be breaking a school rule, and the judges of the district court have bare knowledge, and we should defer to them to make an informed decision.
Alright, does anyone else have any other opinions? No? Okay, let's put it to a vote. How many people rule in the favor of the defendant, Matthew Fraser? Okay, and how many people rule in the favor of the plaintiff, the Bethel School District? Then it's settled. 7-2 in the favor of the plaintiff. Fraser's rights were not infringed upon, and the Bethel School District acted with the Constitution by suspending him.
Grace?
But what does that mean?
It means that students have restrictions on their constitutional rights. There's a limit to how much students can express themselves at school.
Well, that sucks. If this ruling hadn't happened, how would things be different?
Great question, Sarah. Well, there would be greater freedom of speech and expressions in school. More controversial subjects would probably be discussed by students in an academic setting as a result of a different ruling.